Hi, my name is Robert Shelley with Shelley Law, and my law firm assists veterinarians with employment contract and independent contractor agreement issues. Today I'm going to talk about examples of breach of contract for a veterinarian. Every vet is going to have some kind of employment agreement or perhaps an independent contractor agreement. And in that document, there's going to be a section that's called termination. And this just kind of dictates how the contract can be terminated. And it could be for a number of reasons. One could be through mutual agreement. Two, it could be without cause, meaning there'll be a section that states either party can terminate the agreement for any reason with a certain amount of notice to the other party, usually 60 to 90 days. Maybe the contract term just ends and just automatically terminates. Or what this video is about is kind of the normal ways that either the employer can breach the contract or the vet themselves. So in the contract under termination, it will have a section that's called for cause. And so they're usually on the employer side, they're going to list a bunch of things that they can fire the vet for, either immediately or with some kind of notice. And so normal things they can immediately fire the vet for, obviously, if you lose your license to practice, maybe your DEA, you're uninsurable perhaps, there's some kind of major felony conviction involving some kind of moral turpitude, extreme behavioral issues, substance abuse, disability, that type of thing. Those are the things that you can be fired immediately for. Now, there are other things you can be fired for that requires what we would call a cure period. And so maybe to say the vet is showing up late or they're not calling in with enough notice to take time off. Maybe they're being extremely slow and getting through their caseload each day, whatever it is. If the employer believes that the behavior of the vet breaches the contract in some way, but it doesn't rise to the level of an immediate termination, they'll have to provide notice to the vet. Usually it will be stated how much time the vet then has to cure the breach, so to fix the problem. And it's usually somewhere between, like 5 days to 30 days. 2 weeks is probably the average amount. And so if there was some kind of issue about the vet not showing up on time or whatever, not meeting the volume expectations, they would give the vet 2 weeks. If they did fix the problem in that 2 week period, then they couldn't be terminated for cause. So those are kind of normal ways of getting terminated, by the employer. Now, on the vet side, the normal ways that a veterinary practice could be in breach of contract would be, and the vast majority of these claims would be based upon payment, meaning the vet's not being paid on time, or more specifically, if there's any kind of bonus calculations based upon net collections, and the practice is either not calculating it correctly, or perhaps not paying the bonus, the way that it's written into the contract, that would be something that a vet would, kind of say that you're in breach of contract, and then the cure period would still apply here. So they would have, let's just say, 2 weeks to fix the problem, meaning start to pay the vet in the contracted amount, or the frequency that it said that they weren't doing. And then if the practice does do that, then the vet can't terminate the contract for cause. Now, as I said before, the vet will always be able to terminate the contract without cause with a certain amount of notice. So for any reason, at any time, either party can usually terminate the contract, as I said before, with 60 to 90 days notice. So even if all those things, all the kind of for cause reasons exist, the vet can still submit notice, and then they'd have to work out whatever period it was, and then they can leave. The benefit of the for cause termination is just it'd be a quicker out. And then in some cases, there's language in the restrictive covenant section, so like the non-compete, non-solicit, that type of thing, that says those things won't apply if the vet terminates the contract with cause, for cause. And so that would be one way of a vet getting out of a non-compete, would be if the practice continues to violate the agreement in some way, doesn't cure the breach, and then the vet terminates it with cause, and then the restrictive covenants won't apply. If I were a vet negotiating a contract, I would absolutely want to make certain there was language in the contract that states if the contract is terminated for cause by the vet, that the non-competes wouldn't apply, and then maybe if there's any kind of if it's a claims-made malpractice policy, that in that scenario the practice would be responsible for paying for tail insurance. So those are kind of normal ways that a contract can be terminated for a breach. Hopefully that was helpful. If you have any questions about your employment contract or independent contractor agreement, feel free to contact my law firm at the phone number listed below in the description. Our website's down there as well. And hopefully that's helpful. All right, appreciate you watching the video. Take care.